Hello everybody, I'm back again with another video. This video is basically going to explain what does it mean when different agencies or government corporations continue to try to collect payments from you after you done prove your innocence in court and it was ruled fraud. So if you ever had a case and you was taking somebody to court for fraud, listen to this video. An agency continuing to collect on proven fraud. Now, proven fraud is violating federal and North Carolina laws. The Fair Debt Collection Practice Act, the FDCPA, and the NC Collection Agency Act, they are prohibited from using unfair, deceptive, or abusive tactics to collect debts not legally or lawfully with the 14th Amendment owed. So basically, if you're wondering what prohibited means, it means it's not allowed. It's a no-go. The word prohibited does not mean legal. It's something that's illegal. It's prohibited. So with that being said, let's go to more deeper context of the laws breached in North Carolina. If you had a fraud case and you went to court and proved your innocence and they still harassing you, this is the laws breached in North Carolina if they do such things to you. NC Collection Agency Act, the NCGS Statute 58 through 70 through 115 prohibits, meaning do not allow, collecting any interest, fee, or expense incidental to the principal debt unless legally entitled to it. Collecting a fraudulent debt is called basically an unfair practice, especially after you have already proven fraud. And if I proven fraud, or if you proven fraud and they continually try to take debt from you, they're violating federal and North Carolina laws. If you didn't know, now you know. So for this right, the NC Debt Collection Act, the NCGS Statute 75 through 51 to 75 through 56 prohibit debt collectors from using fraudulent, deceptive, or misleading representation, as in false mail, as in false weight, false height, false information. Basically, that's false representation or misleading representation to collect a debt that is not legally owed. So let's go down and dive deeper. Let's go down and dive a little bit more deeper. The federal, right here, we're right here. The Federal Fair Debt Collection Practice Act, the FDCPA, prohibits unfair or unconscionable means to collect or attempt to collect any debt. So what does unconscionable mean? Meaning the person is not conscious of what's going on. They was not aware of what's going on, but they're trying to collect the debt. Like prime example, say if somebody that's not from your home state, right, sends you a bill, just say from Iowa, but you stay in California. They send you a bill for something that you're not conscious of having, to the point they even go to the further extent to send you a piece of fake bill in the mail to make you pay a payment that you're not legally obligated to pay. So that's what unconscionable means, to collect or attempt to collect any debt. The FDCPA prohibits unfair or unconscionable means to collect or attempt to collect any debt, or attempt to collect any debt. So let's go to the next one. Prohibited acts by debt collectors, the NCGS Chapter 75, Article 2. This law prohibits debt collectors from using deceptive representations. Specifically, they cannot falsely represent the character, intent, or amount of debt, continuing to claim you owe a debt after receiving proof of fraud. You see that? It likely falls under this category right here. NCGS Chapter 75, Article 2. Go and check it out for yourself if you don't believe me. So basically, specifically, they cannot falsely represent the character, intent, or amount of debt. So let's talk about the first part. They cannot falsely represent. So if you wasn't a person who received papers and they had gave it to somebody else, that means that is prohibited. They cannot do that. They have to serve or make sure you are the person indeed who is going to pay on the debt. So if they make one mistake in any of the information that's entitled to the debt, therefore that's prohibited to make you pay on something that you was not legally or intentionally notified about. I would say that. So let's go to the next one. North Carolina Collection Agency Act, NCGS Chapter 58, Article 70. This requires collection agency to be licensed and prohibit them from using unfair practices to collect or attempt to collect any debt. And for the last but not least, violations of debt collection statutes are automatically considered unfair or deceptive in North Carolina, which can lead to additional civil penalties. And these civil penalties for each violation can be from up to $400 to $5,000 per incident that happens. So if you want to save your agency or save your face, I wouldn't say practice unfair practices, because it's going to bite you in the long run. So I hope you learned something tonight. Tune in for more videos. Subscribe to my channel. I'm out.